Hi. So let's get started with the Indian Contract Act 1872. Well, it is one of the oldest mercantile law of India that came into effect from 1st September 1872. This act is applicable to entire India except Jammu and Kashmir and deals with all the contracts that are formed within the Indian territory. The first definition that we need to study under this act is that of contract itself. They have been defined under section 2H of the act as an agreement which is enforceable by law. Thus, the two essentials of a contract would be there should be an agreement and there should be enforceability by law of such agreement. When an agreement cannot be enforced by law, it is not said to be a contract. It is mere agreement in that case. But what is an agreement? Well, agreement have been defined under section 2E of the Act as every promise and every set of promises made for a consideration for each other is said to be an agreement. Thus, where there is a promise and a consideration for such promise, an agreement comes into an existence. And when such agreement is enforced by law, it becomes a contract. Now, let's understand what is a consideration. Consideration has been defined under section 2D of the Contract Act as when, at the desire of the promiser, the promisee or any other person on behalf of the promisee do or abstains from doing or does or abstains from doing or promises to do or abstains from doing something, such an act or abstinence or promise is said to be a consideration. Reading the definition, we get an idea that the consideration must always move at the desire of the promiser. It can be made either by the promisee or somebody on behalf of the promisee. Thus, a third party can be involved in paying the consideration. Next, it is very important to understand that consideration can be both past, present as well as future. For example, you can render your services for a consideration that you've already received in past from somebody. You can make on the counter sales, which would be an example of the present consideration. You give something to the other person and you get the money in return. Then you can actually receive advance or for the services that are to be rendered in future. So consideration can be past, present as well as future. Now, when we know what is a consideration, let's get to the other aspect of an agreement, that is a promise. Promises have been defined under section 2B of the Act as when a person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted. The proposal, when accepted, becomes a promise. Thus, when a proposal, or as we say, an offer, is made to somebody and the person gives his acceptance thereto, we say an acceptance has been done. Now, a proposal that is accepted is a promise. So, when I say something, when I offer you something and you accept to receive that offer from me, it is said that there is a promise between us. So this is a promise. And the person who is making an offer is said to be an offerer or the proposer. And the person who is accepting the proposal or to whom the offer has been made is known as an offeree or the proposee. The definition of proposer and the proposee have been explained under section 2C of the Act. So, for a promise to come into existence, we need a proposal and we need an acceptance thereto. But what do you understand by a proposal? Well, proposal has been defined under section 2A of the Act as when one person signifies his willingness to another to do or to abstain from doing anything with the view to obtain the assent of that other to such act or abstinence, he is said to make a proposal. Thus, when I intend to offer something, when I have willingness to do something or to not do something, and I convey it to another person from whose acceptance I am demanding, as in I want the other person to accept that, it is said that there is an offer. So these were the important definitions of the Act, and let's recapitulate. So when there is an offer and acceptance, we say that a promise comes into an existence. When a promise has a consideration, we say that there is an agreement. And when there is an agreement that is enforceable by law, a contract comes into existence as per section 2H of the Act. These were the important definitions of the Act. I hope there is a clarity and you guys enjoyed this video. Have fun.